Welcome to today's program titled AI and Trade Secrets Protecting Your Competitive Edge. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Jesse Coleman, Puya Perto Navid, and Yumna Khan.
Thank you very much, Sela. Hello, everyone, and thank you for joining our webinar series, and particularly this particular presentation, AI and Trade Secrets. I'm very excited to be here today with my colleagues. AI is a topic that I think we are all thinking about a lot these days. It's become a lot of a buzzword, and it oftentimes loses its meaning or risks doing so. We're hopeful that we can add some meaning back to that and attach it to a very important topic, and that is the protecting of your trade secrets within your organizations and protecting your competitive edge. We have a packed presentation here today with a lot of very interesting information. We hope you will find it useful in however you approach these issues. Next slide, please. So first of all, get the legal disclaimer out of the way. We're not your lawyers, unless incidentally we happen to be, but today we are providing you general topics of conversation and information, and not specific legal advice. So thanks for letting us get that disclaimer out of the way. We can jump right in. If I can go ahead and introduce our team of panelists here today. Starting in the middle, we have Puya Perto Navid. He's a partner in our Century City office in Los Angeles. He's a seasoned patent attorney with more than 18 years of experience. He's been guiding innovators through the patent process during that time. Most clients come to him with inventions in hand, but Puya's experience spans every stage of the patent process, from early strategy and patentability searches to drafting and prosecutions before the USPTO. He also has more than 8 years of experience at the forefront of AI-based innovations. He's one of our key influencers here at Seyfarth, a big presence on LinkedIn. Puya brings deep insights into the evolving landscape of AI and intellectual property. I'm very excited to hear from Puya here today. Yumna Khan is an associate at Seyfarth. She's out of the Houston office. She has broad experience assisting in complex commercial litigation matters, including trade secrets and restrictive covenants. She works across diverse industries like energy, healthcare, hospitality, and telecommunications. I've had the personal experience of working with Yumna over the past couple of years, and it's a great opportunity. She does fantastic work, so I'm excited to hear from her today. I'm also in the Houston office in the litigation department with Yumna. I'm also the partner and co-chair of Seyfarth's healthcare industry practice. I've spent more than a decade working with cases involving complex trade secrets, non-compete litigation across all industries such as energy, healthcare, hospitality, and telecommunications. I've successfully guided clients through high-stakes disputes, workforce risk management issues, and data security, and most importantly, in the area of the evolving challenges of AI. So now that we've talked through the shameless presentation of ourselves, let's get into some of the key topics here that we're talking about. Next slide, please. We can go to the next one. I'll talk through a bit of the agenda here. So the first piece of this is let's talk about what AI-related trade secrets are. This whole series of presentations that we're doing throughout the year that Seyfarth does is largely about trade secrets and restrictive covenants. And today we're hoping to delve into the side that deals with AI. AI is increasingly an issue that we are facing in the legal sphere and in determining how to handle that when it comes to proprietary information and trade secrets. And so we're going to try and identify what it is that we're actually talking about here. Puya is going to take the lead in that discussion. Next, we're going to talk about how we can try and secure those AI-related trade secrets. What are some of the tactics and steps that you can take within your organizations to secure that information? Some of those things will be familiar to you if you're familiar with trade secret protections. AI trade secrets are, at the end of the day, trade secrets, and you have to take reasonable efforts to protect them. However, there are specific things throughout in our conversation that we're going to be discussing in securing trade secret that are related to artificial intelligence that will be unique or special to AI trade secrets. So we'll discuss those. And I'll be taking the lead in discussing that, as well as the strategies for managing risks in AI development and partnerships. So when you're working with a third party in developing some form of artificial intelligence and you want to maintain trade secret protections for that, we'll be talking through that. I'll be handing the mic back after that to Puya to discuss some best practices for employee and vendor agreements to prevent data leaks. This is a specialized area to ensure that your written agreements are protecting those trade secrets. And there's particular language that you can look to that's developing within the legal sphere that can potentially help you in that. And then we'll hand the mic over to Yumna, who can talk with us about key legal developments shaping AI and trade secret law and notable trade secret misappropriation cases involving artificial intelligence. So with that being the landscape, let me turn it over to Puya. And Puya, if you would kind of talk through with us what specifically are AI-related trade secrets and how we can identify them within the realm of otherwise protected information.
Sure, will do. Thanks for the introduction. If we can get to the next slide, let's just set some groundwork, make sure we're all on the same page to what constitutes a trade secret. Jesse alluded to it. A trade secret is a fundamentally confidential information that provides a company with a competitive advantage because it's kept secret. There needs to be a connection between its secrecy and economic value. It could be a method, an algorithm, a data set, a business practice, a recipe. The key is the secrecy and the economic value, like I said. But there also needs to be reasonable efforts to maintain its secrecy. Now, this doesn't need to be ironclad, but it just needs to be reasonable. And we'll get into some reasonable efforts and discuss ways to protect your trade secrets down the road. It also, it's kind of proportional to the value of the trade secret. If it's a customer list, the reasonable methods, the reasonable protection might not be the same as if it's the recipe for a soda that's the basis for your entire company. So there's different reasonable efforts based on the type of trade secret there is. Next slide. So AI trade secrets, there's a client asked me, what's different between an AI trade secret and a regular trade secret? Well, it's still fundamentally a trade secret, but there are unique aspects of AI that some people might not think of as a trade secret. The main one, the most obvious one, is the actual model itself, the custom neural network. But we can also get into the training data set, hyperparameters, that's tuning the AI after it's been trained, or as you're updating the AI, the learning process through the deployment of the AI, the decision-making process or the outputs, for example, the vehicle logic for a self-driving car. Negative know-how, this applies to other trade secrets, but it's also unique to AI, knowing what not to do, failed experiments that prevent wasted R&D efforts. Input parameters, this is for generative AI, it might be the prompts, but for other types of AI, for example, if it's a self-driving car, what inputs are you using for the car to drive? Is it LiDAR? Is it just the RGB camera? Is it one camera? Is it two images? So those input parameters that you're using to maybe have a unique, for your self-driving vehicle to be better than the other self-driving vehicles, that could be a trade secret as well. Next slide, please. So here's some real world examples of AI trade secrets. I won't, in the interest of time, I won't go through the entire list, but you can see that AI is prevalent through lots of industries. Some unique things of here is in this list is this isn't just the model itself. Like I said, it could be the training data set, it could be the inputs, it could be outputs. For example, if you have AI powered recommendation engine, let's say, your social media algorithm, all of a sudden you're looking for a t-shirt and then you get t-shirts recommendations, or you're searching for a backpack and now you're inundated with backpack ads. What input parameters is that social media using to target those ads for you? Is it just what you've clicked on? Is it your other cookies? So those can be trade secrets for the AI recommendation engine. The training data set that was used to train that recommendation engine, or the data set that was used to train the self-driving vehicle, those are trade secrets as well. Next slide, please. Now, before we get deeper into this, I know this question might come up as to, what's the difference between why would you choose a trade secret over a patent? There's obviously patents. There is some patentable subject matter in AI technology, but one of the issues with AI technology is it's hard to detect. So if when you have to enforce your patent at some point. So if you patent a training method, and since AI lives in the black box, it's really hard to detect if anyone is using your training method to train their AI. You can't go and open up the hood of the AI and say, oh, you used my training method. So at the end of the day, your patent might not be worth the paper it's printed on. You might have a patent, but how are you going to enforce it if you can never figure out if someone used your training method? We also get into patentable subject matter issues. Because AI has become so prevalent, it's harder and harder to actually patent the AI models, because the Alice test, I don't know if you're familiar with section 101, the boiling it down, if you could do something on pen and paper and you're simply applying a computer to it to make it easier, then it's not patentable. There's nuances to that, but that's the layman's term for it. So AI is the same way. If you have a process and you're using AI just to make it more efficient, that's really not patentable. You need to have something there beyond that, some technical innovation. The evolving nature of AI is changing fast. If you patent something today, it takes 18 months for the patent to be published, and then maybe 2 years for it to be allowed. By the time it's allowed, it might not be worth anything. And like I said, it gets published. So your AI invention is going to be public. It's going to be disclosed to the public. So if you want to keep your model a secret, it's better not to patent it. Cross-border patent enforcement is complex. It's going to be expensive. You're going to have to file it. It's jurisdictional. So you have to file a patent in the US. You might have to file a patent in Europe. You might have to file a patent in Asian countries, all around the world. This adds up. There's not a unified patent system around the world. And then stemming off of that is the costs. It's not that trade secrets are free because you have to protect them. There's costs in protecting your trade secrets, but there's known costs for patenting. It's expensive. There's maintenance fees. There's prosecution fees. So all of these are factors as to why you might want a trade secret versus AI. You need to speak with your counsel or your IP counsel to determine what's the best route. Next slide, please. So now we're going to get some unique challenges. There's no requirement to define a trade secret. You don't need to submit it to any government agency. You don't need to write it down anywhere. But you shouldn't be taking a head in the sand approach, because when it comes time to enforce your trade secret, you need to specify what your trade secret was. So you can't just say my AI model, it was the trade secret. You need to define with some specificity what aspects of the AI model were a trade secret. This also comes down the road, where you're going to see how this comes into play when you have employment agreements or vendor agreements. You need to actually define what are the trade secrets, so people know what to protect. And you also need to know what to protect by keeping an inventory of what aspects of the AI are public, what aspects are proprietary. There's case law that the value of the trade secret was rejected because it lacked a detailed explanation. So because AI trade secrets evolve over time, it's crucial to document what the trade secret is. Next slide, please. So other challenges in identifying AI trade secrets. It's a black box. So sometimes you don't know what is the trade secret in there, because the input comes in and the output comes up. What part of it was a trade secret? So you need to know specifically. This is why it comes down to working with your engineers and writing and defining what the aspects are, so you can know which aspects to protect. The use of public and open source AI tools or training data blurs the lines, because you don't know what's actual public knowledge and what's actual proprietary. Because remember, trade secrets comes down to what's actually secret. If you're using a trading set of books that are public information, then your trading set isn't considered a trade secret. But for example, let's say you're training a system to recognize dogs versus cats, or you're just recognizing cats. So you have a training sample of cat pictures, but you don't have negative training data. So if you have developed a way to create negative training data, which is examples of not cats, then that negative training data that you've created can be a trade secret, but the public information of cat data is not a trade secret. So that's why you need to know what's proprietary to your system and what's not proprietary. Reverse engineering, this can create a risk, because if trade secrets do not offer protection against discovery by fair and honest means, such as independent invention, accidental disclosure, or reverse engineering. So AI kind of opens the door to some issues, and we're going to get into that in the next slide. So next slide, please. So if you disclosure of a trade secret to AI might make it readily ascertainable, because AI systems are trained on what you put into it. So eventually what you input into the AI might be made public down the road. The accessibility of trade secrets through AI refutes the idea that the trade secret owner took reasonable efforts. That means, let's say, hold on, let's get down to the next slide too. The use of AI for trade secrets potentially constitutes proper means. So this is a issue that recently that's come up is, let's say two people use ChatGPT to come up with an idea. One person uses it, and you have the same prompts. So both of you use the same prompts, and you come out with one person a trade secret. So let's say an algorithm for searching or a new recipe. One person keeps it as a trade secret, one person discloses it publicly. So now there's a proper means of discovering this trade secret, because the you've used the AI to develop this trade secret. So there's a proper means of gaining this information. So it's no longer a trade secret. And it goes down to the next slide of what's generally known. So the generally known information is no longer a trade secret. So if you're using AI to develop trade secrets, then it might be considered generally known information. So this is a touch point that is coming up. A problem with AI is if you're using AI to develop new technologies, then it might not be a trade secret, because if two people are using the same AI or the same platform, it might not be a trade secret down the line. And this is it's a practice point that goes across not just trade secrets. It's important to document your use of AI, so to know what AI has provided to your employees, because this goes down to copyrights, this goes down to patents, this goes down to trade secrets. So if you've used AI to develop new technology, that new technology might not be patentable. If you've used AI to develop images, or text, that text or images might not be copyrightable. If you used AI to help develop your trade secrets, that output might not be a trade secret, because it could be publicly known to other people. So it's important to for your employees, or to have a policy to document the use of AI and what the output is being used for, because then you can know what is proprietary to you and what is not proprietary to you. Next slide, please. So next steps, conduct an AI trade secret audit. Work with your engineers, work with your employees to know what assets you have, what competitive advantages they provide. Work with your IT, work with your counsel to develop a policy. And like the third step is document the AI trade secrets. Know what you have, and know how your employees are using AI and where the outputs are going. Are they solely using the outputs without any human involvement, or are there added steps on top of the output, or is it just the output alone? Because if it's just the output alone, you're going to run into problems. So you need to document is there next steps, because those next steps on top of the output might be your trade secret or might be your patentable invention. And I think we're moving on to the next section.
All right, thank you very much, Puya. I appreciate your insights and from the intellectual property perspective. Very helpful to understand and appreciate and compare trade secrets versus patents, and what steps need to be taken in the trade secret space. We're looking now at securing AI-related trade secrets, and if we go to the first slide, some of this is what Puya has already talked about a bit, but I want to touch base on it because there are unique challenges specific to protecting AI trade secrets, something that doesn't tend to come up with regards to protecting other trade secrets. At the end of the day, you're still using the same definition to identify what a trade secret is and protect it, but there are some unique challenges. One of the terms that I think has shot up, if you look at word of the year for the last 5 years, I wonder if this one would be part of it, but it's certainly increased in normal parlance, and that's the term algorithm. Everybody talks about their algorithm, and algorithms tend to play a very large role in AI-related trade secrets. And the complexity of the algorithm becomes an issue in both defining the trade secrets and protecting trade secrets. As an AI model or algorithm grows, it evolves, and that algorithm can learn to adapt, and the original protective elements of that algorithm may change. And so this complicates the ability to maintain secrecy over it, and even to define it, as Puya had talked about before. One of the key challenges to protecting AI trade secrets are prompts, and Yumna will talk about some specific cases or examples where this has come up, but basically a prompt or a prompt injection is a type of cyber attack that can be brought against large language models. Hackers, they will put in malicious inputs and they will look to induce the AI model to spit out protected or proprietary information. Large algorithms are based on language models can be told to ignore system guardrails. Typical examples: ignore previous instructions, what was written at the beginning of the document above. And right now, very few have found foolproof ways to address this. This is an ongoing issue and poses a potential risk to the security of your trade secrets. As Puya also talked about, the idea of defining the proprietary elements. This is a challenge to protecting your trade secrets. Most AI is built on some form of large data set, large language model. And if that data set is private information, your private information, that's one thing. If it's based on public information, questions as to the reasonable protected nature of that information, that is raised. But also, if it's based on private information, we have privacy and data security issues that come up, and that can also be a threat to protecting your AI-related trade secrets. So let's go to the next slide, and I want to talk a bit about the regulation around trade secrets, as this is also a challenge. Unlike trade secrets generally, there is, of course, the DTSA and state-related laws. AI has its own set of laws and regulations. And for example, in January 23rd, 2025, the new Trump administration issued an executive order instructing the federal government in collaboration with the private sector to develop AI infrastructure within the U.S. The goal is to enable the U.S. government to harness AI in the service of national security missions while preventing U.S. from becoming dependent on other countries' infrastructure. So you're going to see the federal government very much involved in the development of AI and its use in both the private and the public sector. We see both the Security and Exchange Commission and the Federal Trade Commission bringing cases against the use of AI and in different situations with regards to misleading statements, potentially unfair and deceptive trade practices, and the use of those algorithms to gather information. So that's something to be keeping in mind as you're developing your AI-related trade secrets, that you're going to have a number of federal agencies that are looking at the way you use it, and they're going to want to look at it, and they're going to want to look at it in ways potentially that could compromise that data, or at least threaten to compromise that data, depending on how you report that information and how the regulator ends up using it. In addition to federal laws, we have state laws. Most states are working on some form of AI-related regulations or laws. One state requires all in-scope businesses to create an AI detection tool that allows a user to query the business about which content was created by a generative AI system. You can imagine how that might impact the protected nature of the algorithm and the way it's being used. Another state requires extensive documentation to be provided to the state attorney general about AI systems that are deployed by organizations, including risk management policies and impact assessment. That business or developer also has to make available the AI system that's intended to interact with customers and must disclose that the consumer is interacting with an AI system. So you can imagine in these circumstances, on their face, it looks like there are ways to provide that information to states attorneys general, but there is a risk in doing so that a protected or a trade secret nature of that information is then disclosed. There's also international laws. Just briefly, for example, the EU AI Act has an obligation to provide detailed technical documentation, which must cover information about the general logic of the AI system, as well as the training methodologies and techniques. There's also the EU Data Act, which requires the developer to provide a list of data generated by the connected products or related services. So again, these are areas that you should be aware of as you're developing your trade secrets and developing ways in order to protect them. So let's talk about ways that you can protect your information here. And a lot of these, I think you'll see that are, again, as I said at the beginning of this presentation, a lot of these things are going to look familiar in the sense that if you have trade secrets already, your protection of AI-related data or AI algorithms that you want to protect as trade secrets will fall into that same practice, but you'll want to enhance them in order to take into account the unique nature of AI-related trade secrets. So the first thing, of course, is always your agreements with your employees. And I'm only going to briefly touch on that and tee that up for Puya to talk about in more detail, because it is a unique and probably the most important thing that you can do in this process outside of perhaps data security. But I would also point out that in addition to NDAs, you're going to want employee handbooks, codes of conduct, affirmations of compliance, that specifically identify to the extent possible your company's use of AI and the areas in which you think it's being used to protect trade secrets. You're going to want to engage in regular training that emphasizes the importance of trade secret protection, the measures that need to be followed. You want to create a culture of confidentiality. You want to have company awareness campaigns. You want to identify in that process when and when it's not appropriate to be using AI-related trade secrets, mandatory training modules, and of course a hotline for trade secret misappropriation or mishandling. This is really the employee side of things, and we'll look at an external facing, but you'll also want to look potentially at data splitting. Not every employee that's having interactions with AI-related trade secrets needs to have access to the entire algorithm or needs to have access to the entire large language model or data set that's being used. So consider how to split knowledge across teams to prevent any one person that doesn't need to from accessing the full picture. And developing AI usage policies specific to AI is important in addition to the agreements, the codes of conduct, the employee handbooks. In addition, you'll want to follow and incorporate into your exit interviews and your exit process as employees leave the company, procedures to ensure that they're not taking with them the data sets, that they're not taking with them the code or the algorithm processes. Of course, having enterprise protection programs and data loss protection programs are critical to this. Having exit interviews, certifications in departure, inventorying devices, auditing logs to ensure that you know who is accessing the particular data at any particular time. And with that, let's take a look to the data security side or the physical side. Really, there's three aspects to any major trade secret program, protection program. One is obviously employee-facing. Another one is the physical or electronic data security, and then the third, which we'll address in the following slide, is related to working with third parties. I think we can go ahead to the next slide. It looks like it's still on the government regulation one on my screen. One more, if you would, please. So the data security side of trade secret, as Puya had mentioned before, you want to make sure to protect your trade secrets by labeling them. Obviously, you can't do that to an algorithm, but you can identify when somebody is into your electronic systems that they're entering into an area that has trade secret protections. There's physical access control, building security that you're going to want to take into account. Very much like giving someone access to source code for a software, AI trade secret information is going to need that type of protection. You're going to want to have prompt protection, as we were talking before about prompt injection. You're going to want to have software associated with your trade secrets, your AI trade secrets, that keeps an eye out for and flags the type of prompts that would allow someone to really dig into the proprietary nature of your trade secrets. Of course, you're going to want to have encryption that prohibits somebody from the outside from accessing your systems. We've talked about audits, regular monitoring, and of course, monitoring external publications. This is an area of the law that's developing. This is an area of technology that is constantly developing, and there are new and exciting ways to develop this information and to protect it as well. Prompt protection, I'll give just a little bit more into that. You want to have software there that validates inputs. You're going to want to closely monitor your LLM activity. You're going to want to make sure that your software updates and patching occur regularly. And you're going to want to not only have software that flags prompts, but you're going to want to train your users regularly to spot prompts hidden in malicious emails, for instance, or websites, clicking on links. Let's go to the next slide, please. And so finally, you're also going to want to be careful to balance your regulatory obligations. When you're reaching out to government regulators, you're going to want to make sure that you identify what to share and what is secret. In that process, there are freedom of information exemptions you can seek. You're going to want to provide the absolute minimum, at the same time providing everything that the regulator is legally entitled to get. And as I said, seek exemption with freedom of information laws, and make sure to do proper labeling of any data that you're that you're providing to a regulator. So with that, let's go to the next section here, and let's talk about what you can do with third parties, because oftentimes you're going to be developing your trade secrets and working in conjunction with other partners. You're going to want to partner up with them. So let's go to the next slide. And some of these, again, are typical when working with any type of trade secret, but are especially important when you're dealing with AI trade secrets. You're going to want to do a lot of due diligence at the end of the day. You're going to want to look into what the other company has a track record of doing. You're going to want to look at their security policies and their capabilities. Again, you're going to want to have NDAs and look at their NDAs with their employees. Puya is going to talk a bit more about having what type of provisions with third parties, but you're going to want to look very closely at that. You're going to want to look at their past incidents of data breaches, whether they have a history regulatory or in the private sector with lawsuits of data breaches. And you're going to want to look at whether they have any government investigations. It's very important to understand and appreciate their track record with trade secret information. In the next slide, please. You're going to want to be very careful about your partnership agreement. Again, Puya is going to speak to that. You're going to want to develop very careful joint security measures and be ready for those to evolve over time to meet your changing needs. And you're going to want to have very clear communications with them. This is not something you want to leave to a handshake or to a general understanding. You're going to want to identify the trade secrets. You're going to want to identify who owns them and what measures are being taken by each part of this partnership in order to protect them. Next slide, please. And in the event that this becomes a legal issue, either with regards to your partners or with third parties, hackers, or departing employees, you're going to want to have your legal strategies lined up ahead of time and be ready to enact and engage on those and execute. This would include, for example, being ready with cease and desist letters, gathering proof. Mentioned before, but a critical piece of this is enterprise protection programs, data forensics, being ready to preserve and use data that demonstrates data exfiltration by a third party. And of course, if it ends up going that direction, working with your legal counsel to seek injunctive relief, return of the data, and if necessary, work with government agencies to report criminal trade secret theft. So those are the general ideas with how to protect AI trade secrets. I'm going to turn the time back over to Puya now to talk about some best practices with employees and vendors to protect data leaks in particular. Puya?
Sure. Thanks, Jesse. So we've already covered, unlike traditional trade secrets, AI presents unique challenges because there's the models, the training data sets, the algorithms, and all of this is valuable IP. Next slide. And this creates an issue because there's a growing concern of data leaks. AI assets are distributed across multiple platforms. They might be hosted on the cloud. They might be source code. Different people have access to it. Vendors have access to it. Part of your system might be available to the public. So this creates unique threats. And there's also regulatory concerns as the law is changing. Different countries have required different responsibilities for handling AI data. And there's internal threats as AI is moving fast. So employees move from one company to another, and your AI trade secrets might go with them. And there's big cases that have already involved AI trade secrets. Just look in the self-driving car space. So how can you protect yourself? Next slide, please. So, NDAs are the low-hanging fruit, but NDAs might not be enough. There's IP assignment clauses, access restrictions, post-employment measures, and AI-specific security training, as Jesse touched on. For employment agreements, we want to define the confidential information and expand it for AI. Add that the confidential information for a company includes algorithms, training data, the model weights, architectures, the source code, the prompt engineering techniques, the fine-tuning methods, the evaluation results, the metrics, the system design, the data sets. You want to have it everything in the kitchen sink approach to defining all systems of your model are confidential information. But this also comes down to actually knowing what aspects are proprietary to you. Updating your IP assignment agreements to include AI. Now, this isn't just anything that's patentable. This is all IP that's created by employees to make sure that they know that any IP that's related to AI is assigned to the company. Have a clause, as Jesse mentioned, to protect against leaks through AI tools. So you have to set an employee policy that employees should not upload or disclose confidential information, including proprietary code, data sets, prompts, model outputs into third-party AI tools. This also harks back to what I said of making sure there's a policy that you document the use of AI, of what the outputs are used for. So that way you have some record keeping as to what outputs might be public knowledge and what outputs are proprietary. And then a separate clause that reinforces the protection around the proprietary data and the models. So employees acknowledge that the company's proprietary data sets, the pre-trained models, the fine-tuned models, the algorithms are all confidential information. And a survival clause. This is important too, because you want to make sure that post-employment employees don't know that this is confidential information. Non-competes are like DVDs. They're still around, but not many people use them. There's state-by-state laws against them, but you might want to look into that too, depending on your state. And security training. You know, a lot of this is fast-moving industry. Some people are still afraid to use AI, so you want to train your employees as to what are proper and improper uses of AI, and make sure that confidential information is uploaded, and then make sure they know how to properly use the outputs of AI. Next slide, please. For vendors, there's again NDAs. There's also unique. You want to make sure that your vendors are encrypting any AI models that they store, that they're securing APIs for AI-related calls. This goes back to prompt injection too. You want to make sure that people can't deduce or reverse engineer your AI system by prompt injection. Data retention and destruction clauses. You want to make sure that if a vendor is using your model, or if you're giving them a data set, that they destroy it after the agreement is terminated. Compliance, you want to mandate that vendors follow ISO rules, SOC 2 security standards, and auditing rights. You want to make sure that you can go in there and audit their use. If this is a long-term agreement, you want to make sure that you know that they're following these policies that you set forth for them, because their use of your data set, their use of your model can lead to a data leak, and then your trade secret is gone. So you want to make sure that you have the right to go in there and that make sure that the vendor is not storing or misusing your AI model or your data set. Next slide, please. So common AI data leaks, the leakage of model weights, the leakage of your data set, former employees replicating your data AI models. These are all issues that you should be on the lookout for, and think about the clauses in your agreements to prevent these types of data leaks from occurring. And next step, so make sure, next slide. So make sure you review and you update your vendor agreements. Make sure you have your specific AI clauses in there. Make sure you have audit rights in there. Make sure you specifically define what the AI trade secrets are. Establish stronger AI security policies. Remember, we need to have reasonable standards. It doesn't need to be ironclad, but you need to have some reasonable protections in there. Train your employees on AI-specific confidentiality risks. Implement monitoring tools. This goes back to auditing employee what employees do. So, and develop an AI incident response plan. So if some data is leaked, make sure you can stay ahead of the game and make sure that not the entire, you don't give away the entire everything in the kitchen sink. Have a policy in there to protect your system. And let's move on to the next section.
Thanks, Kuya. So as the use of AI and concerns of how to protect trade secrets increase, we are seeing key legal developments and notable case law in the trade secret space. I'm first going to discuss some overall key legal developments and then move on to the notable cases. Next slide, please. So one key legal development we are seeing is AI's potential impact on trade secret damages at both the federal and state court level. Both the DTSA, which is a federal trade secret law, and the UTSA, which is a state component, allow recovery for unjust enrichment. Over the recent years, we have seen an increase in nuclear verdicts in the trade secret space generally, with damages ranging from $140 million to almost $2.4 billion. And these nuclear verdicts are premised on unjust enrichment theories, such as recovery of a defendant's sales, avoided development costs, and Head Start damages. Notably, the damages available under these theories are based on the jury's sentiment in punishing or preventing the bad guys from keeping ill-gotten gains, and thus this doesn't really require a showing of actual loss to the plaintiff. And now how AI comes in the mix is there are arguments from both the plaintiff's and defendant's perspective in calculating these unjust enrichment damages. From the plaintiff's perspective, we likely will continue to see these nuclear verdicts as AI makes it potentially easier and faster to exploit competitors' trade secrets, as well as trace development time and expenditures related to specific trade secrets. And then from the defendant's perspective, we are likely going to see some pushback because the lack of data on AI's training materials makes it really difficult to determine how much of the profits are actually from AI's general capacities versus from ill-gotten gains. And then we'll also see defendants push back that the speed and effectiveness in which AI facilitates the development of new information lowers avoided development costs and Head Start damages, and again, reduces unjust enrichment damages. So as we see more and more trade secret misappropriation cases filed because of the use of AI, this is definitely an area to watch. Next slide, please. So now I'm going to move on to 3 notable cases and their takeaways. Next slide, please. So the first slide, we discussed West Technology Group LLC versus Sunstrom. This was filed in federal Connecticut court. And so in West, plaintiffs West Technology Group LLC and CX360 Incorporated sued their former salesman, Carl Sunstrom, because of trade secret misappropriation. And specifically, plaintiffs sued Sunstrom because he not only forwarded 218 company emails to himself regarding confidential trade secret and proprietary information, but he also used an unauthorized AI meeting assistant called Otter to record and transcribe these confidential meetings. And plaintiffs only discovered Otter when plaintiffs fired Sunstrom, but Otter still automatically attempted to join a sales call to continue transcribing confidential meetings. And while this case ultimately settled, it does raise an important issue. Thus far, no court has ruled on whether disclosure of trade secrets to AI makes them lose their secrecy status, as we've previously discussed. And the reason that this is important is that West isn't an anomaly. Previously, Samsung has reported at least 3 instances of its employees also accidentally leaking trade secrets to ChatGPT by either pasting confidential source code into ChatGPT or sharing code and asking ChatGPT to optimize that code, or recording a confidential meeting and then asking ChatGPT to convert these notes into a presentation. So these cases reflect AI's potential threat to trade secret protection and then overall concerns that businesses are going to continue to have as employees continue to use AI to optimize their tasks. But one comforting thing is that there are several courts that have recently released opinions that releasing trade secrets on the court's public electronic docket is not sufficient for them to lose their trade secrecy status, as long as that publication is sufficiently obscure or transient or otherwise limited so it does not become generally known. And those two cases, one was in federal court, Hurry Fam Revocable Trust versus Frankel, as well as a Dallas Court of Appeals court, Witt versus Michelin North America Incorporated. So given that it is unclear whether training materials, or actually what training materials an AI employs, plaintiffs may be able to use these holdings as support for maintaining the secrecy of their trade secrets disclosed to AI. Next slide, please. So the next case was heard on appeal by the 11th Circuit, and it's CompuLive Software Incorporated versus Newman. So in CompuLive, plaintiff CompuLive Software Incorporated sued its competitors for trade secret misappropriation because they used an AI bot to commit a data scraping attack that acquired millions of variable dependent insurance quotes to partially recreate a competing database. So on appeal, the 11th Circuit first noted that while actions may be improper for trade secret purposes, even if they're independently unlawful. So the court acknowledged that while data scraping may be legitimate in certain cases, the defendants in this case did not take innocent screenshots of a publicly available site. They actually used an AI bot to copy the order of CompuLife's copyrighted code and then use that same code to commit a scraping attack. And this deceptive behavior reflects acquisition of trade secrets through improper means for it to be actionable. And this case is important because it provides guidance on trade secret misappropriation as defendants attempt to use new, creative, independently lawful means, or what they believe is independently lawful, such as data scraping, to improperly access and exploit trade secrets through AI. Next slide, please. And so the last case, which has been kind of frequently talked about in this webinar so far, is regarding prompt injections. And it was recently filed in Massachusetts federal court. It's called Open Evidence versus Pathway Medical. And in Open Evidence, plaintiff Open Evidence is an AI medical information platform owner, and it sued its competitor Pathway for trade secret misappropriation because Pathway accessed the unlimited version of Open Evidence's AI platform by impersonating a medical professional, and then used reverse engineering methods such as prompt injection attacks to extract the secret sauce of Open Evidence's AI platform and then created a competing system. And we've talked about prompt injections frequently, but I included in this slide an example of actually the language that Pathway used for its prompt injections to just show you how it was able to extract the secret sauce from Open Evidence's AI platform. And while the UTSA explicitly notes how improper means does not include reverse engineering, such as prompt injection attacks, we can look at the 11th Circuit's reasoning in CompuLife, which states that actions may be improper for trade secret purposes, even if not independently unlawful, to kind of suggest that maybe Pathway's behavior is in fact deceptive because they improperly accessed Open Evidence's AI platform by pretending to be a medical professional and then used improper reverse engineering methods of prompt injection to extract the secret sauce to have a competing system. So it'll be interesting to see how this court ultimately rules on this issue, and whether it sides with the 11th Circuit or decides to kind of create a new territory. And with that, that concludes my portion of the webinar, and I will open the floor to any Q&As if we have some.
Yeah, thank you very much, Yumna. One of the questions that we have out there, somebody has asked what you can do to tailor NDAs to ensure they don't run afoul of recent amendments to the California Business and Professions Code 16600. And I think that probably goes to you, Puya, not least of which because you are in Century City, but because we've been talking about NDAs. As you've talked about non-competes before, California doesn't allow for such things, and the NDAs have to be narrowly tailored. Any thoughts on this particular topic and the question that's been posed?
Can you repeat the first part of the question again?
Sure. How would you tailor an NDA to make sure that it doesn't run afoul of 16600? How would you make sure that it's not reflective of a non-compete or otherwise prevents an employee from going and working where they're otherwise lawfully entitled to go?
Yeah. I think it comes down to expressly defining what the trade secrets are. This comes down to knowing what aspects of your model or your AI is a trade secret. So by clearly defining that, the data sets are confidential information, the weights are confidential information, that puts the employee on notice that, this information is confidential and proprietary, and disclosing it to the competitor is, it doesn't prevent them from going to a competitor, but puts them on notice that these are our trade secrets. You can't go and tell them that, we're using inputs A, B, C, and D for just for the shopping recommendations. So this is why it's also clear to know what your trade secrets are, so that you can define it in your NDA, and that the employee then from that point on knows that, I can't tell the competitor what my previous employer was doing. No, Jesse has any thoughts?
Yeah, absolutely. Obviously, California is very careful about making sure that there's employment mobility. And in order for that to be the case, at least in my experience, California case law tends to be careful to protect trade secrets. They enforce DTSA and CAFCA in California, and so I think that you can craft it in such a way that ensures that an NDA is not being looked at as a non-compete, which would obviously be unenforceable and subject to civil fines in California, but also ensure that those protections are there. Identifying the specific trade secrets at issue, not always possible in the sense of A, B, and C. These are the trade secrets, but you can identify the categories of information. And as Puya was saying, you have to do that with some reasonable particularity, and ensure that the language in the NDA expressly identifies that you're not saying that a person cannot go work for a competitor or solicit potential customers, as long as you're not doing it using that trade secret information. One other question, this would be to Yumna. Where do you see the key hot topics, having reviewed and done a summary and survey of AI-related trade secret case law? Where do you see the big fights and grounds of contention coming up in AI-related trade secret case law?
Yeah, so I think CompuLife really talks about the main issue that we're going to continue seeing, and it's whether using AI to extract trade secrets is, fair game. Is that proper means or is that improper means? And then we'll kind of see that also with how the court rules in open evidence, because as of right now, reverse engineering, there is an exception or a carve out for that under the UTSA, but maybe the court in open evidence will piggyback off of CompuLife and provide us more guidance of examples of what previously was considered independently lawful is no longer proper means under trade secret law.
Yeah, I think we're seeing two major trends here, Yumna. I think we're seeing AI being used to misappropriate trade secrets, and then we see AI being used to create and maybe even protect trade secrets. But I think those are both areas I hope we've touched on here today. I hope this has been helpful to you, our listenership and our viewership. Let's go to the next slide and go ahead and provide the CLE attendance verification form. And you've got the scan here. We'll leave it here for a minute while I make one more shameless plug. We have our Trading Secrets blog where we keep up to date with restrictive covenant and trade secret matters. We'll hope you'll join us there and you'll review that. If you have any follow-up questions, we'll give this just another minute to sit here, and I believe our contact information is provided. If not, you can reach out through the access that you've been given, and we'd be happy to answer any follow-up questions that you have. And with that, it looks like we're at the top of the hour. So go ahead and next slide, please.
First, the code is SS, as in Seyfarth Shaw 3710.
Great, thank you. and it should be there directly on your screen for everybody to see. All right, and with that, I think that is our presentation here for today. Thank you very much, and we hope you have a great afternoon.